right, morning, everybody, and welcome to this update. This is going to be a short session this morning. Can I ask that those of you who joined online, if you can just mute yourself? I'll just mute you here, and then we'll take questions at the end. This is not a very long judgment, but it is of quite particular relevance, particularly in my practice, insofar as it deals with an urgent application to review SARS's decision to refuse a suspension of payment application, and whether or not, in the circumstances where SARS withdrew, subsequent to institution of proceedings, where the taxpayer is entitled to punitive costs, right? Which makes sense, because let me tell you this: to get counsel on an urgent basis to appear and to be briefed and prepare a review application is particularly expensive. I suppose it depends on who you use. But the question here is effectively about costs. For those of you who don't know me, I'm Nico. I'd studied some tax. Right? This training is intended, as always, for my staff. For those of you joining online, it's really just for your interest's sake. Right, guys, so the factual background is that SARS raised additional assessments for 2017 to 2023. And the alleged liability, I can see it's this, we know that we think we know the taxpayers, but the alleged liability was approximately 40 million, including penalties and interest, right? The taxpayer objected, and of course, as is the practice, requested suspension of payment, but SARS refused the suspension application, referring to prima facie fraud, insufficient proof of irreparable hardship, substantial assets, and the interest of the fiscus, outweighing the prejudice to the taxpayer. And SARS warned that collection proceedings could follow if the taxpayer didn't pay them the 39.9 million rand. That's a substantial tax liability, right? We recently had a matter where the tax liability was 100 million rand. We also did a suspension of payment. They granted that one, fortunately. But here, SARS said no, they're not granting the suspension of payment, and the issue was whether or not SARS was right to do so initially in the urgent court. But this judgment deals with whether or not SARS' subsequent withdrawal of the opposition and changing their decision to, okay, fine, I will grant suspension, whether or not the taxpayer is entitled to punitive costs. Right. The taxpayer, because SARS refused the suspension of payment, asked SARS to reconsider, right? So we do the Section 11, probably did Section 11.4 and requesting a Section 9 review, right? As is normally the practice before you institute action against SARS. And the correspondence sent by the taxpayer to SARS warned that urgent High Court relief will be sought if SARS did not reconsider. No reconsideration was given or standstill was granted before the taxpayer then instituted the urgent High Court application. And in this urgent High Court application, the taxpayer sought interim restraint of collection pending the review of SARS' decision to refuse payment, right? And then a review and setting aside of the refusal to suspend payment. So there was urgent relief, restrain, stop them from collecting, and then whilst we are reconsidering the review application of SARS' decision to refuse. SARS initially defended the refusal and disputed urgency in a comprehensive answering affidavit. Right? This is all relevant, I'll tell you now why. The issues really is, for this case, the judgment that we're discussing here is whether or not the taxpayer can get punitive costs or not. Because here, there's a 39 million rand liability that SARS is threatening to collect. They refuse suspension. You ask them to reconsider. They refuse again. Now you have to get a lawyer. You have to get counsel, and you need to get on the urgent court roll. All of those things are ridiculously expensive, and all of them are caused by SARS' refusal to grant suspension, and then again SARS' refusal to reconsider it when asked to reconsider, even on threat of urgent High Court application. So the question was initially, can the taxpayer have launched urgent review? Was the taxpayer entitled on an urgent basis for urgent relief? And two, was SARS' conduct so reprehensible that the court must justify it with a punitive cost or own client scale? For those who are not familiar with the concept, you get different scales at which you recover costs, right? So, and these costs are prescribed. And normally, if you get a normal cost order, your attorney charges you much more than what the cost order is. But an attorney-owned client cost is to recover the cost that your attorney actually charged you. So when you get a cost order, it is not that you get all the costs of your attorney. Often it's only a small percentage of the cost. It's a small recovery. But attorney-owned client scale or attorney-client scale is whatever the lawyer charged you, that's what the other party must pay. And that's what they were asking here. They were asking the court to say, look, can you please order this punitive, it's called a punitive cost order. The taxpayer, the court said, yes, you can. So therein, you can launch an urgent application. Therein already lies something very important. Because here's a judgment, and I think it's the Joburg High Court, if I remember correctly, where in the circumstances of this case, there was sufficient cause for an urgent application. Urgency is not something that you can easily establish in litigation, right? Urgency here was a 39 million rand liability and an immediate threat by SARS to enforce without any indication of backing off, because they continue to say we're refusing and we continue to take collection action. So therein lies an important principle, is the ability to seek urgent relief in consequence of what is normally the biggest immediate issue for a taxpayer in a tax dispute, is the leakage. SARS raises some ridiculous assessment, right? Sometimes it's not ridiculous, right? Most of the times that we work on it, it's some ridiculous assessment, right, that we need to dispute, and they want to collect the thing, right? Now they say no, and taxpayers often for, well, now I'm at SARS's mercy. Yes, you would bring a review application, but you bring a normal review application, it's going to take forever. This tells you that you might, in circumstances, have urgent access to the urgent court, but the taxpayer unfortunately failed on punitive costs. They got costs, normal costs, but not punitive costs, right? Right, when punitive costs are appropriate, just by high-level summary, attorney and client costs are extraordinary and awarded only sparingly, says the court. They allow recovery of materially greater portion of the successful party's actual legal expense. Their central function is to express the court's marked disapproval of the losing party's conduct. Right, typical examples include dishonest, fraudulent, vexatious, frivolous, reckless, or abusive conduct. And I put emphasis on those words because I think they bear quite some relevance in practice. Right, an ultimate unsustainable legal position without egregious conduct. So in other words, SARS's position, so we incorrectly disallowed it the first time, or we changed our mind to grant it subsequently, is not necessarily enough. Right, the taxpayer, of course, wanted punitive costs, and the taxpayer could only rely on the sequence of events, because they said, I asked, you said no. I asked you to review at the threat of legal action, you said no. I launched my application. You launch an answering affidavit, and then you withdraw the case and change your decision to grant suspension. It took the taxpayer's argument was, if I had not launched this, you forced me to bring this application, and your conduct, the sequence of events suggests to me that I had to bring this application to get you to actually do your job properly. Which, when you were faced with an urgent application, you realize, some committee somewhere realized, oh goodness, we actually made a cock up here. We need to withdraw. That was effectively what the taxpayer was asking, right? But what was SARS's response? SARS said no. They said they're not liable for costs at all, let alone punitive costs. They say their withdrawal of their decision and the replacement of their decision was just part of their ordinary administrative process. They would have reviewed the decision anyway, right, in their normal course of things. It's not because the taxpayer instituted litigation action, right? They would have normally, in the normal course of things, they would have suspended it. Now, I can tell you this much, right? I'm quite annoyed with respect with this judgment, but I'll tell you this much. I have seen this many times before. You do something, you ask them, they say no. You say, I'm going to take it to court, they reconsider it, they say no. You bring a review application, it's almost as if then somebody else goes and says, oh goodness, now we actually have to look at this properly. I'm not saying that's the truth, I'm saying that is my perception. So I must be careful with what I say. I'm saying that is my perception. We do this every day, right? We had a case the other day where a week before the matter was set down, right? SARS's counsel reached out and said, we'll concede the application, can we just sit down, we'll even pay your costs. Not punitive costs, we'll even pay your costs. But now my question is, was that, how is that sequence of events part of your normal administrative process? It's not, man. You're changing your mind because there's a risk of litigation against you. That's why. I mean, the issue is for the taxpayer, unfortunately in this case, I think, is they couldn't prove it because they were only relying on the sequence of events. Okay, but I'll talk about it. SARS says this is just part of their normal administrative complex, of their administrative process. They consider thousands of Section 164 suspension of payment applications, and the taxpayer gave no evidence of bad faith, dishonesty, or abusive process, which is true. The taxpayer kind of wanted the court to infer what I just explained. Do you follow? Which is fair. I mean, the court can't infer things not not substantiated in evidence, right? So I get it. That doesn't mean I'm not annoyed with the result, but I understand the judgment. Right. The court said that the sequence of events alone did not prove litigation forced SARS to abandon an indefensible position. I'll get to my criticism. The merits of the review were never argued or adjudicated. So in other words, whether or not SARS's refusal was properly arrived at, whether that decision wasn't adjudicated because it was never taken on review, because SARS changed their mind and granted it was the part B of the application was a review of SARS's decision, but SARS withdrew, right? So the issue of whether or not SARS's decision was correct or not the first time around was not decided. And SARS did not concede in changing their mind, at least the court says so. SARS did not concede that their original position was wrong. They said that initially we reviewed it, and on the facts before it at the time, I said no. And when I reconsidered it on apparent new facts, I don't know where the new facts, SARS will argue the new facts arose in the founding affidavit that supported the urgent application. We reconsidered the application, and so they're not saying our original decision was wrong. We're just saying we reconsidered the decision. And so perhaps in SARS's defense, the argument is that the original suspension of payment application wasn't properly drafted or set out. And this, to be in SARS's defense, this often happens, is that when matters come, when the taxpayer realizes the thing is too serious and it starts coming to us and we start looking at it, we say, well, look on what was presented to SARS. I think if we take it on review, we'll probably lose, but we need to, if we do a new one and then they reconsider it, right? So SARS is saying, my original decision wasn't wrong, I just reconsidered the facts again. That was their position. How much of that is supported in the facts, we would never know. But the court found no bad faith or abuse of process or willful disregard of rights. The delay or slow reconsideration of SARS's decision, even if it's open to criticism, the court says it was not enough without further reprehensible conduct. And SARS withdrew the argument. Now, the court here says something important, is he says, and I get this point in the question of punitive costs. He says, we want administrative action that is lawful and procedurally fair, and we want to create a safe space for organs of state to self-correct. Right? If we grant punitive cost orders in matters like these, we will prevent organs of state from self-correcting because their mind will now be, if I now change my mind after the institution of legal action, right, now I'm at risk of a punitive cost order just because I withdrew. So the argument is that not granting or allowing punitive costs would allow for self-correction. The criticism I have with that is why should it take legal action for self-correction to take place? I think with respect, the argument is slightly misplaced. A punitive cost order will, in fact, in my mind, ensure that correction is made before action is instituted, not afterwards. Yes, it's an issue of timing, right? But my concern is why must I institute action first before you self-correct? So I'm not entirely convinced. Whilst I get the logic that you don't want to scare organs of state to self-correct, because the argument is that if we don't allow this, or if we allow punitive costs, they might either at risk of getting a punitive cost orders run a case that has no merits because they don't want to withdraw, right? Because that gives them open to. So I get it, but still, I mean, this feels like a long shot to me. Right, SARS says they looked at section 164 and its refusal was never mala fides. It looked at it, it reconsidered it when the matter reached litigation again, and it just changed its mind, right? The sequence of events is not enough, right? But what my issue is here is, look, this case doesn't say you can never get a punitive cost order, but it says you must prove that there's some form of egregious conduct on the part of SARS, which is going to be very difficult because the reality is all the so-called internal discussions or whatever it is that they said in reconsiderations is not on record. I suppose one can ask for it in terms of buyout, though they'll probably refuse it because it's internal processes which they're not obliged to give. So it's going to be very difficult to prove some form of egregious conduct if you don't have access to the information in front of SARS. But what you can do is you can make sure that you build a factual record and ask SARS, here's the suspension, come back, why did you disallow it, on what basis, give me reasons, do this, keep a record of things so that you can build this evidence back, so that you can get this, try and show egregious conduct. Because, like I said before, it is, in my and this is kind of my criticism, we'll end with this, I think, and then we'll open to questions. I've seen this before, where one gets the distinct impression, I can't confirm this to be true, but one gets the distinct impression that it's almost as if they see how far the taxpayer is going to push before they cave, right? I'm not saying that is true. I'm saying that that is the perception that's often created, and this is the perception that was clearly created here. That's why the taxpayer went for punitive costs. So I had to push, I had to bring urgent application, and then you conceded. Why didn't you just allow it the first time around when I asked? Right. The issue is you'll have to explain that you'll have the burden of proving that there was some form of egregious conduct, and good luck with that. Right, so the important takeaways from this judgment for me is more that urgent relief might be available in circumstances like these, which is very important. Two is the taxpayer did get costs. I must add, the taxpayer did get costs, but not punitive costs. And the court said costs are justified in the circumstances, but not punitive costs, right? And not that this judgment says, it's the Ferreira judgment that actually says that you can take a decision by SARS to refuse the suspension of payment on review, right? And they do tend to refuse suspension of payment applications. They do so more frequently nowadays. In the past, it was normally run-of-the-mill allowed, I think, to a large extent, whereas nowadays they tend to refuse it. And the issue is you can't object to a decision by SARS to refuse a suspension of payment application. It's not a decision subject to objection and appeal under Section 104. So your recourse will be a High Court application, right? In this case, it was sufficient to bring it on an urgent basis, but then costs is going to be your issue. Right. And bear in mind that withdrawal and timing alone is not going to get you punitive costs.